rule on whether Donald Trump is immune from prosecution for the alleged crimes he committed while he was president. We're going to cover all of this on The Lead today, starting with my very first guest, who served as the top law enforcement officer under Donald Trump and then famously broke with him over the election lies. With me now in studio, former Attorney General Bill Barr. Thank you so much for being here, General Barr.
Good to be here, Jay.
What's your initial reaction?
Well, as you know, I strongly oppose Donald Trump for the Republican nomination. But I think that this case is legally wrong and untenable. And I think this kind of action of stretching the law, taking these hyper-aggressive positions to try to knock Trump out of the race are counterproductive. They backfire. As you know, he feeds on grievance, just like a fire feeds on oxygen. And this is going to end up as a grievance that helps him.
So the Colorado Supreme Court made its ruling based in part on the district court in Denver. And the district court found that Trump did engage in insurrection. And this is what they said. Trump acted with the specific intent to incite political violence and directed at the Capitol with the purpose of disrupting the electoral certification. When the violence began, he took no effective action, disregarded repeated calls to intervene, and pressured colleagues to delay the certification. The court finds that the language Trump used throughout January 6, 2021, was likely to incite imminent violence, and therefore that petitioners have established that Trump engaged in an insurrection on January 6, 2021 through incitement, and that the First Amendment does not protect Trump's speech. Beyond the decision by the Colorado Supreme Court, do you disagree with any of that?
I disagree with the court's ability to make those findings. The core problem here is the denial of due process. To deprive somebody of the right to hold public office requires due process. It requires an adjudication of two core issues. One, was there an insurrection? Did the public disturbance rise to the level of an insurrection? And second, what was the role of the individual in there? Was it engagement? Did they do something to break their oath of office? Those are complicated facts, and this was denied due process. It was a 5-day hearing. There was no jury. It was before the judge. They were not able to subpoena witnesses and compel the attendance of witnesses. They relied on the hearings, the January 6th committee hearings, which is mostly hearsay. There was no right to cross-examine during those hearings and so forth. So as the dissent said, and by the way, the three Democratic justices who dissented, their opinions, I think, are masterful. And as they pointed out, they said, the process here was a procedural Frankenstein.
So I'm sure that if your friend Liz Cheney were here, she would say that the January 6 hearings was not mostly hearsay, it was mostly witness testimony. But beyond that, let me ask you first. First of all, let me just ask you, as a D.C. legal hand, how do you think the U.S. Supreme Court is going to go with this? Do you think they're going to take it up and rule against it? What's your best guess?
Well, I think if they take it up, they're going to slap it down very quickly. And I hope they do take it up quickly and slap it down, because otherwise he could be left off the ballot in this primary.
So if I'm hearing you correctly, you're not even saying that you disagree necessarily with what the district court and then the Colorado Supreme Court found in terms of insurrection. You just think it's the wrong process. You think they're, like, for instance, Jack Smith's trial, although he's not actually charged the president with insurrection.
Yeah, legally, the denial of due process is fatal here. But as you alluded to in your opening comments, the 14th Amendment is not something that can be applied willy-nilly by the states through sort of ad hoc proceedings. It was contemplated that the federal government set up the enforcement mechanism, so you have some standard. What is the proof that's required? What is the procedure that is required? And hopefully some adumbration of what exactly the insurrection is. Now, we're going to have those issues addressed.
Yeah.
Now, he hasn't charged, Jack Smith has not charged the president. The federal investigation has not charged President Trump with insurrection or incitement. But that's a trial that's going to take place with due process, and it's going to get into all these issues. What was his state of mind? What were his actions? That is the kind of proceeding where these things could be established.
Would Jack Smith's case be relevant to a 14th Amendment challenge? In other words, even though Trump is not being charged with insurrection or inciting an insurrection in that case, if Trump were to be found guilty, and who knows what's going to happen, but if that were to happen, would that be grounds for a 14th Amendment challenge in a state, do you think?
Well, I'm sure it could prompt that, but my own view of it is that the federal government, the mechanism that's in place is charging him with insurrection or rebellion. And and Congress did pass that after the 14th Amendment. Congress passed two laws that were meant to implement it. One was the ability to remove someone from office, and that was passed in 1870, and it was done away with in 1948. And the other was making it a crime to breach your oath and then hold another office. So to engage in rebellion and insurrection. And I think that's what would be required at this stage.
Do you think